Welcome. Today on Know Your Rights New Jersey, we will discuss the basics of employment discrimination. And to help us navigate this important area of the law, we are fortunate to have with us two superb attorneys, Andree Peart, who is a legal consultant, and Jaacqueline Tillman, a solo practitioner, both experts in employment discrimination. Welcome.
Thank you.
Thank you.
Thank you for joining us. Let's start with Andree. Tell us a little bit about the basic types of employment discrimination. Some of us believe that racial discrimination is the only type, but
Well, certainly there is racial discrimination counted among the various types that you encounter in the workplace, but there is also discrimination based on other protected categories, if you will. Those include gender, national origin, religion, disability, age, certainly. They may also include, for example, things that one don't typically consider as being among protected categories, but that could be sexual orientation, certainly genetic traits. So there are many different types of categories within which one can possibly claim discrimination. Veterans, for example, as well, recently have brought claims of discrimination successfully under new laws which protect them from employment discrimination as well.
Jackie, these categories, how as an employee would I know what type of categories I fall in, or how would I know?
Well, sometimes it's easy. If you're an employee and you're feeling that you're suffering some kind of harassment or discrimination, you probably have some gut feeling about what that's based on. I typically feel that if I have a potential client giving me a call and they feel that there's discrimination, but they have no basis for what they think that is, that's already a warning sign. So if you're thinking that an employer is treating you differently, right, you probably have some gut feeling that it's because I'm a woman, or it's because I'm Jewish, or it's because I'm Hispanic, that you have that feeling. It's because of my disability, or it's because of my sexual orientation. Usually the potential client or the employee comes in with a feeling, this is what I think is going on. Now, as professionals, we may have an additional spin to that, but though the protected classifications that Andree mentioned are the basic categories, and you would have a feeling of what's going on if you think you're being discriminated against or you're thinking you're being harassed.
So for both of you, when employees come into your office and you have some doubt, because you're expressing that sometimes they have a feeling which indicates some doubt, but that something's going on that's not fair, how do you help them identify whether there is something really going on that's discriminatory, and discriminatory in a way that it can be either adjudicated or resolved within their environment?
In my experience, and I get a lot of calls, the phone rings often. I have to explain to the employee, there's kind of fine line, there's a little bit of a dance. And we have to look at what is happening specifically in the workplace. What's going on? Do you feel like you're being harassed? Who's harassing you? What are they doing? What are they saying? How often does this happen? Is it a one-time event that's very severe, or is it something that continues to happen over and over? And we'll talk about that a little more later. But that's the first thing I ask. There's a difference between unethical behavior and illegal behavior.
Okay. Important. Yes.
So, and that is pretty much the fine line that we have to navigate through. If the employer is treating an employee badly or even unfairly, it doesn't necessarily automatically rise to the level of discriminatory or inappropriate illegal behavior just because it's unfair. So, for example, if an employer is treating everybody mean, if he's a bad guy, if he's a jerk, if he's got a nasty mouth, if he's nasty to everybody, we call him an equal opportunity jerk. Yes. But if he is singling an individual out because of one of these protected classes, one of these protected categories, then we can look a little further into whether it truly is discriminatory behavior. Is he treating this person differently because of her gender or because of his gender, because of his sexual orientation, because of his disability, because of his color? Those are the things we look for. So is it kind of a but for your protected class, would they be treating you the same way?
Andree, is your experience with your clients, and I know you do both management, both of you do both management and employees,
Yes.
But focusing on employees, is your experience with them similar when they come to you?
Yes, actually it is. And what I have found to be the single most valuable directive or piece of homework that I've given to those inquiring about the possibility of a discrimination claim is, who are your comparators? And by comparators,
Yes,
I mean,
please.
who are those individuals who are not of your protected category, who are being treated differently from you and presumably better than you? And I ask them to identify any individuals they can, because without that basis for comparison, it's difficult for myself as a lawyer who is providing perhaps an advisory opinion, or for a judge to discern the employer's motives, because likely the employer has its own unique perspective on why the employee is being treated in a manner that the employee obviously feels is unfair. So I need to see how others who are performing similarly to you are being treated, who are not of your race or your religion or do not have your disability. And in that context, then it becomes clearer whether the motive is truly discriminatory and unlawful, or perhaps, as Jackie said, an employer who just doesn't like you, and there's no legal protection from being disliked, unfortunately.
So it sounds like both of you are saying it's important for the prospective client or
Yes.
a person who's being discriminated against, who may not be a client,
Sure.
for them to understand their workplace, not just understand how they're being treated,
Correct.
but to understand what's going on around
Exactly.
them.
Correct. Absolutely.
So, is there a need for them, once they start to identify some problems, to start taking notes? What should an individual do?
I do recommend taking notes. Start a journal per se about the workplace incidents. I recommend that they write down the date, what happened, who was involved, if there were any witnesses, and what was said. And you want to keep a bit of a chronology. I often find if an employee themselves is on the fence about, is this really because of my race? Is this really because of my gender? If you start keeping a bit of a chronology, it will appear that you will see a pattern of behavior. And so I think that's important. I also think it's important to keep notes, because if it's gone on long enough, often you'll forget little incidents. And they can be very important if things progress in terms of lawsuits. So it's very important to record that. I would give the caveat that if you're doing that, I recommend to people not necessarily to do it in the workplace.
Or on their computers in the
Or on their
workplace.
computers in the workplace, because that is the employer's time and that is the employer's property.
Correct.
So there have been occasions where individuals said, I wrote these notes and they're my private business, but they were taking time away from their work and doing it at that time.
Right.
And that would make it more discoverable, where it may not be. And sometimes we want it to be, and sometimes we don't want it to be. But if you do it when you should be working, or you're doing it on your workplace computer, that takes that away. So I recommend do it on your lunch hour. Go to your car and do it on your lunch hour, or go home and record it. And definitely don't do it at work because that's their property and they have the right to go in and it might disappear one day.
Okay.
So you want to protect that.
Okay. Andree, what is the most common type of discrimination that you've seen in your practice?
Well, I do think that both sexual harassment and retaliation are among the more frequent claims that evolve out of employees' concerns. And let me start by saying that employees will frequently come to me, and I'm certainly to Jackie as well, and they give you an emotionally fueled list of grievances that may or may not equate with a legal claim. It's important, I believe, to listen to what they have to say because A, they're venting, and B, there may be legitimate claims within those grievances. But to the extent that sometimes they are alleging a claim of discrimination that doesn't really meet the legal threshold to be qualified as unlawful employment discrimination, they nonetheless can bring a claim to HR or to the administrative agencies that address such employment discrimination charges, and their claim may be found not to have any legal weight. However, often what I find occurs is that there may be an unfounded discrimination claim followed by what arguably is a legitimate claim of employment retaliation. Mm-hmm. Now, employment retaliation is when the employer, human beings all, are told you discriminated against someone that they know or ardently believe they didn't discriminate against. But human beings, being what we are, when we are wrongfully accused, sometimes we respond in kind. Mm-hmm. And we vent our spleen. Employers have to be, and are cautioned not to respond in that way, but when they do, perhaps by isolating that employee or by changing his or her benefits, by changing their work schedule or giving them less desirable work assignments, that can constitute retaliation for which that employee who didn't have a good discrimination claim now has a great retaliation claim. Mm-hmm.
Jackie, in this first segment, with the few seconds that we have left, talk to us a little bit about what a hostile work environment is.
Mm-hmm. I frequently have people calling me saying, I have a hostile work environment. I have a hostile work environment. And sometimes they do and sometimes they don't.
Aren't most work environments hostile? No, I'm just kidding.
I think working is hostile.
Absolutely, I agree.
But in terms of the law, hostile work environment, it's that the employer or someone in the employment arena is doing something that is impeding on the rights of the employee. To flesh that out, add some flesh to that. They are changing the atmosphere because of their behavior towards that employee. It could be hostile comments that are on their face hostile. You're a jerk, you're stupid, you're dumb. It could be like that. Now again, that has to be because of that protected classification. Okay? But they're changing the very nature, the very atmosphere of the workplace. They have changed it to become hostile. They could be not saying anything. They could be putting pictures on the wall. Pictures of nude women. That would make, and maybe they're not saying anything to the woman who was working there, but she now feels she works in a hostile work environment because of these photographs. Frequently things come over the computer. Racist jokes, sexual jokes. If they're continuing to come and management is either originating them or not doing anything, that can be argued that it has changed the nature of the atmosphere at work. It has made it hostile. So typically, the courts have found that a hostile work environment can come about because of one incident that is very severe or several incidents that are very severe, but it only takes one if it's severe enough, or if it's pervasive. So not necessarily severe, but it happens over and over and over and over and over again. That's pervasive. Either of those or those together can result in a hostile work environment. So an employer can routinely call his female employees sweetie and honey and girly, but they refer to the male employees as Mr. Ponder.
Right.
It's not one severe incident, but if it happens over and over again, the opportunity, the door is open for the female employee to argue, well, wait a minute, I think the atmosphere here has changed. I think I'm being treated differently. I feel like it's discrimination. Examples of one incident of an employer changing the atmosphere with one incident. There's a case called Lehman versus Toys R Us. Yes. It involved executives at Toys R Us. This is years ago. It's a landmark case, but a African-American executive was doing interviews with her supervisor and a couple other executives looking for a high-ranking person to join them. During the course of the interviews, they interviewed several people of different races. At a break, they all went to the bathroom. The African-American woman went to the female bathroom. The white males, they happened to be white, all, went to the male bathroom, and they happened to exit at the same time, despite the fact that usually women take longer. But they exited at the same time. And the plaintiff in that case, who was an African-American woman, heard her supervisor, high-ranking, say to the man behind him, did not see her, we do not want to hire any more jungle bunnies. So prior to that time, there had not been any kind of she had not felt that there were any racial tensions in the workplace. She did not feel disrespected. But that one incident of hearing her supervisor describe African-American, Black people as
Certainly.
jungle bunnies completely altered the workplace environment. So that's another example.
Well, Jackie, that's a wonderful, wonderful explanation. I interrupted because we're going into break, and we look forward to coming back and hearing more of this great conversation.
Yes.
We'll be back in a few. Thank you. You're back with Know Your Rights New Jersey, and we are here with Jaacqueline Tillman and Andree Peart discussing employment discrimination. Let's now talk a little bit about how employees who think they may be discriminated against file a complaint against their employer.
Well, I think initially, the employee who feels that he or she has a discrimination claim needs to complete his arsenal, if you will. You need to be sure that you are prepared to demonstrate that you have a discrimination claim based on how you've been treated in comparison to others who are outside the category about which you're complaining. But also, you need to look at your employer's policies, because if your employer has a complaint procedure, you do want to use it. It might be able to resolve the matter quickly. And even if we can't be that optimistic and it doesn't really address the matter fully, it does show that you made reasonable efforts using the tools that the employer has made available to you to address the concern that you have. As Jackie mentioned, you document the bases for your concerns, not solely because you'll be taking it to a lawyer. Some matters never get to a lawyer, but even if they don't, you want to demonstrate to your employer that you are fueled not just by emotion, but that you have facts and dates and data backing up your claim that you have been treated differently. Without that, even if an employer wants to address your concerns, they're not going to have much to go on. So it's important for you to be armed with information about your employer's policies that prohibit discrimination, perhaps, and that support your contention that you're supposed to get that promotion or that raise. And then you also need to have the documentation showing when and where you were treated differently.
And if I could just add,
Please.
In many cases, if the employee does not avail themselves of that written procedure,
That
if they don't
process.
follow the process to some extent, if they don't at least try, that and it ends up in litigation, that might be a complete defense, a successful defense
Sure.
by the employer. Look, we have a policy, you never told us. You never followed the policy. How could we do something? And to be fair, it's a fair and reasonable argument.
Right.
So an employee really does have a duty to follow the procedure. If there is a procedure, there's not always a procedure.
Right. And
But
if there's not.
and if there's not, but even if there is not a procedure, it is important for the employee to complain. Now, they can call a lawyer before that if they want to and talk to them about what they think would be good. Most attorneys would be happy to speak with you and give you some ideas about what you need to do. But regardless, you have to complain, because if you don't, the employer has an absolute defense, I did not know.
Correct.
And I guarantee you, they will always say it. So it's very, very important that they do that.
So Jackie, what should that employee look for in situations where unions are involved? I always have found that to be a very complicated.
It can be complicated, and just because a union's involved doesn't mean it's going to help you. But that is yet another mechanism for following the procedure. So if there is some requirement that you work through a union, you need to do that. You need to try to do that. If nothing else, it's going to document that you have a complaint. It's going to document that you were unhappy. It's going to document that you made a claim about XYZ happening in the workplace. So that's important. I don't think employees can always rely on their unions to represent all of their rights.
So if they can't, and my experience has been that they can't always rely on their unions, but that they often must go through the union process first or go to the union first. When do they approach other consultants or attorneys to help them? And what is an attorney only good for a lawsuit or for writing a letter and scaring the employer or trying to scare the employer?
By no means. Unfortunately, many employment discrimination claims arise, or at least employers become aware of it, lawyers become aware of it, when it's completely adversarial, or the employee has suffered what is called an adverse employment action. They have lost their job, they've perhaps been demoted, some action has been taken against them that, quite frankly, had they come to a consultant, be it an attorney, an HR professional, not necessarily one affiliated with their employer, but someone who understands employment law well enough to advise them at an earlier stage, it could have been avoided. So certainly, I think the stage at which you marshal your resources, that means looking, if you are union represented, at your collective bargaining agreements, grievance procedure, and whether it covers discrimination, looking at your employer's complaint process, documenting what you think might be the beginning of a problem, is the stage at which you feel, while still employed, that I'm not necessarily getting the benefit of all of the resources that are made available to advance the careers of others in X category. I, in Y category, am not getting the benefit of all of those resources. And then I think the first thing you try to do is give your employer the benefit of the doubt and try to get those resources made available to you. Ask for them. Demonstrate a desire and a willingness to advance within the organization, and explain candidly you need some help to know how to do that. And see if you can get some hard answers that will provide the guidance you need to help your career at that stage. Only then, when you have made a good faith effort to use the resources that were made available to you, should you say, my career is languishing nonetheless, I am still being treated differently from these other individuals because of my gender, religion, race, national origin, what have you, my age. And as a result, I think it is now time to think about how to bring a claim, to make a formal complaint. And at that point, certainly, if you have not contacted and consulted with an attorney or another employment law professional up until that point, you should then, because you're going to want to make a complaint in writing to your employer, because as Jackie said, they can't address discrimination complaints they don't know about.
So, Jackie, you seem to be in agreement with that.
Oh, most definitely. And it's fair. I mean, I will say I do mostly plaintiff work. I'm very pro-plaintiff, even though I do management also. And if someone doesn't know something's happening, they can't correct it.
So we only have a few minutes left, and I wanted you to talk to us a little bit about the type of remedies for discrimination. What type of things should an employee be looking for when they feel discriminated against?
Well, it depends on what stage they are. If I file a suit on their behalf, or even if I write a demand letter on their behalf, I'd be looking first for what would you like me to do for you? That's what I say to my clients. Sure. What would, in all the best possible world, what would you like me to do for you? And sometimes, if the employee's still there, or maybe they've worked there for a long period of time, they want to stay in the workplace. I had a client who worked on an assembly line. She had worked on that assembly line for 25 years and had worked her way up through the company. She had barely an education. I think she got out of 8th grade years and years ago, and she had slowly risen through that company. She wasn't interested in leaving. She just wanted to have a not hostile work environment. Right. So what she wanted was, I want to have my pay grade increased, and I don't want people snapping my bra. so maybe she wants to stay there. So sometimes people want to stay. Sometimes they want the employer to do something specifically. We call that specific performance. Sometimes they want that. Sometimes they're out of the workplace and they say, well, look, I've suffered. My salary has suffered. I wasn't paid correctly. So I may want front pay. I may want back pay. So this is looking at the difference of what I would have made if I stayed, or what was denied to me in the past. They could look for emotional distress damages if that's a component of it. Another issue with employment in New Jersey is punitive damages, which are something that strikes fear in the heart of employers. Punitive damages are damages to punish.
But for their behavior.
For their behavior.
Employers
Yes.
for their behavior.
Yes. So this is an amount where, this is an area where juries are given quite a lot of latitude. If the behavior is particularly egregious, and it has to rise to quite a high level, yes. Then the employee can get punitive damages, and that's plainly to punish the employer for doing that.
Well, you mentioned in New Jersey, and so let's end with a New Jersey specific question, which I'd like for both of you to answer. What is the environment for resolving employment discrimination, a good one in New Jersey currently, in the courts and in the business world? If it is, is it a good environment?
I think, and I don't know if Andree would agree with me, I think New Jersey is a fantastic place to be an employee. I will say that. Our New Jersey law against discrimination is very strong. There is a fee shifting statute within that allows the employee to collect attorney's fees which they normally would have to, if they won, they would have to turn around and pay their own attorney. This is for years, possibly, of litigating on their behalf. With this fee-shifting statute, the side who loses, the employer, may have to not only pay their attorneys, but pay the attorney of the plaintiff.
At the prevailing party, yeah.
That's right.
Sure.
So that's very strong pro-employee. So at this time, I think it's very strong. I think it's always been strong. There's been recent litigation involving issues about arbitration, where employers are trying to take away or reduce employees' rights to file lawsuits. Courts have pretty much said no way for that. The employee certainly has their 2 years to litigate. So it's, in my opinion, largely a pro-employee state. I don't think it's unfair, but that's my finding. Andree, what do you think?
Well, certainly having litigated on behalf of corporations that operate nationally, I will say that New Jersey, along with California and a handful of other states, are seen as being more kind, if you will, and to employees. So to that extent, as an employer, you have to be aware of the laws that protect employee rights and make sure that you're complying by them. And yes, it does mean that employees do have the right to litigate their discrimination claims. You can have arbitration to discriminate other types of wrongful termination, but discrimination, for the most part, are typically required to comply with the federal and state laws that guarantee them certain time periods within which to file and which provide for protection of laws that are not protection of employment discrimination not covered by the federal laws, such as sexual orientation discrimination.
Jackie, Andree, you have been wonderful. Thank you for the very informative discussion. We look forward to seeing you next time on Know Your Rights, New Jersey. Thank you.